Very good morning, ladies and gentlemen and friends. It's already time, and I request all the people who are in the corridor and standing to take their seats, and please be seated, because all our dignitaries and chief guests are already arrived, so that your cooperation is very much important and required to keep up the time and make this event successful, enjoyable, and being on time. A very good morning for all my friends and the dignitaries on the stage. It's a Sunday summer morning, of Indian summers we call it. It's rather Hyderabad summer, but I don't think no one can get an opportunity to be so much inside and under the in the auditorium where there is an AC, and we have so many dignitaries here to speak and enlighten us and give us an opportunity to learning. Give a big round of applause to all our dignitaries over here. Indeed, it's a moment of pride for all of us. So to celebrate this precious and prestigious event of Indian Mediation Day 2023 in the presence of honorary and elite guests and speakers and delegates present here, I warmly welcome all the dignitaries and the participants who came not only within India, from also across the globe, only to make this event very successful and very joyful. And big round of applause for all of them who have been here in Hyderabad for the last 2 days and giving their time and learning and enjoying. Thank you. Now I request all the dignitaries to just go forward for lighting the lamp. I've just noticed the lamp has exactly 5 wicks, and we have exactly 5 dignitaries on the stage. Is it a coincidence, or it's a good omen to start this occasion? Because generally when we had lamp lighting ceremony, there'll be more guests and less lamps, or less wicks, or there'll be less wicks and more dignitaries. But it is matched the situation. I feel that it's a good omen, and it's a good start for the day. Now we take this opportunity to felicitate all our dignitaries present on the stage. First is our Honorable former Chief Justice, Shri Ramana Garu. I invite Senior Advocate of Telangana State, Krishna Grandi, to come over the stage and felicitate the, Justice Ramana Garu. Now we'll felicitate Justice L Nageswara Rao Garu, former Judge, Supreme Court of India, also Life Trustee of IAMC. I invite Senior Advocate, Telangana State, Pusilla Vikram, to come and facilitate the justice. R.V. Ravindran Garu, former Judge Supreme Court of India and life trustee of IAMC. Vikram, please. Mr. George Lim, Senior Counsel and Chairperson of SIMC, and our special guest. Thank you, Vikram, and thank you, Krishna, and thank you, Alia. An ounce of mediation is worth a pound of arbitration and a ton of litigation. That's what Joseph Greenbaum said, and he well said it. And that's the value and importance of mediation. And I'm very happy that there are so many professionals who are taking it up, mediation as one of the conflict resolution process and helping the parties involved. And IAMC, ever since it was inaugurated by our Chief Minister, Mr. K. Chandrasekhar Rao, and our former Chief Justice, N.V. Ramana Garu, in December 2021, 18th, IAMC has taken this ADR and mediation in letter and spirit. With the state-of-the-art infrastructure in Hyderabad and eminent persons on the board to guide the entire institution, and Mr. Tariq, as a registrar, is steering the entire institution in the right direction and bringing IAMC to the global map. Ever since it started, IAMC gained prominence not only in India, but also across the globe. And every day we see on LinkedIn or in social media our IAMC's name, sometimes in Canada, sometimes in US, sometimes in East Asian countries. And we see Tariq standing there with all the dignitaries and taking a picture and highlighting our IAMC. So as all you know, mediation can work in many ways. And from small cause disputes to multi-track and complex disputes, mediation can work. Why? Because communication is the main technique and the tool for resolving the disputes through mediation. And in my experience, I forgot to introduce myself. I'm Priya Iyengar, advocate and an ADR specialist, I call myself. I'm in this field for the last 25 years. So in my experience, I have seen people have rebuilt their broken relationships when they have a conflict after the mediation process. They got into new businesses and they actually have become friends. That power mediation has. So indeed, the effort of SIMC and IAMC to make this India Mediation Day a successful and fun and enjoying event is highly commendable and laudable, and that wouldn't have been possible without the idea and conceptualization and collaboration with SIMC and IAMC. For giving this opportunity for all of us, I want all of you to put your hands together and applaud their efforts, and also greet them to this mediation world, and thank IAMC and Tariq and all our trustees there. I don't want to introduce Tariq because he has so many qualities, as many as people are around in this hall. So he's an open book. Everybody can take a page and read about him. So now I hand it over to Tariq to give his welcome address of the dignitaries.
Honorable Mr. Justice N.V. Ramanna, former Chief Justice of India. Honorable Ms. Justice Hima Kohli, Judge Supreme Court of India. Honorable Mr. Justice L Nageswara Rao, former Judge Supreme Court of India. Honorable Mr. Justice R.V. Ravindran, former Judge Supreme Court of India. Mr. George Lim, Chairperson of Singapore International Mediation Center. Mr. Wee Ming, the CEO of Singapore International Mediation Center. Gregory Vijendran, Senior Counsel from Singapore, Seng Ong, who's also the lead trainer for the training we did, and the former director of Singapore Mediation Center, honorable judges present here, honorable secretaries present here, senior advocates, mediators, arbitrators, friends from the legal fraternity, fellow colleagues, friends from the press, and my dear students. On behalf of IAMC Hyderabad, it is my great pleasure to extend a very warm welcome to all of you to this special event. As the registrar of this esteemed institution, I'm honored to address each and every one of you as we come together to celebrate our first India Mediation Day. Today is a day of significance and excitement as we gather here to celebrate India Mediation Day, and your presence here today is a reflection of your unwavering commitment to excellence, and we are honored to have you join us. Thank you very much.
Thank you so much, Tariq. Now, it's the time that we hear all the luminaries sitting on the dais. The first one to go is our Supreme Court, our CJ, former CJ, Justice N.V. Ramana. Justice M.N. Ramana has served as the 48th Chief Justice of India. He has specialized in constitutional, criminal, service, and interstate river law matters. He has also served as a panel counsel for a number of government organizations. In the Central Administrative Tribunal in Hyderabad, he served as additional standing counsel for the central government. He also has served as the Additional Advocate General of Andhra Pradesh. In 2000, he was appointed as a permanent judge of Andhra Pradesh High Court. From March 10, 2013 until May 2013, he served as the acting Chief Justice of Andhra Pradesh High Court. In 2013, he was appointed as Chief Justice of the Delhi High Court in 2014. Thank you, sir, for coming. Justice L Nageswara Rao enrolled as an advocate in the Bar Council of Andhra Pradesh in 1982 and practiced in the Andhra Pradesh district courts from 1982 to 1984. Andhra Pradesh High Court 1985 and 1994 and the Supreme Court. He was a former judge of Supreme Court of India and is the 7th individual to be appointed directly from the bar to the Supreme Court, and he has sworn in as justice on May 13, 2016. So there is a lot that we can talk about Justice L Nageswara Rao. I was actually going through his profile. So with the kind permission of the dignitaries and participant present here, there was a very nice Telugu poem written about him. That's the only thing I could find. So with your permission, I'll read out that 5 lines poem about Justice L Nageswara Rao. It is in Telugu. పెదనందిపాడు పెద్ద ఆయన న్యాయ వ్యవస్థకే ముద్ద ఆయన వారికి దాతృత్వం మా లావు కాదు లేదు అనే పదాలు వారి డిక్షనరీలో లేవు పరిచయ మనస్సులు ఎప్పుడూ దూరం కావు హృదయంలో పేద గొప్ప తేడాలు లేవు అరిషడ్వర్గాలు ఎన్నియూ దరికి రావు దేశభక్తిలో త్రివర్ణ పతాకం పొగరు పౌరుషం ఎక్కడికి పోవు అందుకే తీర్పు చెప్పడంలో వారు గంగిగోవు అందుకే వారి మనస్సు ఎప్పుడు కలంకం లేని తెల్లటావు. So this was very impressive and I really wanted to read it, though it took some time, but I took the liberty to read about it. I welcome Justice Nageswara Rao to give his opening remarks. Thank you, sir.
If you ask me to read, I can't read that. Justice N.V. Ramana, former Chief Justice of India, the moving spirit behind the Hyderabad International Arbitration and Mediation Center. It was almost 2 years back when he became a Chief Justice, or just before he became a Chief Justice. He spoke to me about having an international center in Hyderabad, taking into account the interest of the government in improving the economy in this state. So I told him that having such a center would be very good because world over, Arbitrations and other alternate dispute resolutions are institutionalized. Only in this country we are having too many ad hoc arbitrations, and there was a recommendation also made by Justice Srikrishna committee that institutional arbitrations with all its advantages should be promoted in this country. So thank you, Justice Ramana, for being an inspiration to all of us in promoting this center. Justice Hima Kohli, she was the Chief Justice of this court initially when we started this. I remember her, in spite of having her own work, she was going around even to find out a building for the purpose of this center. She took immense interest right from day one. And though being a Chief Justice of this High Court, she was on the board, we thought that it would be fit that she should come on to the board even after her elevation to the Supreme Court. Justice Ravindran, he has spent hours together in getting the rules ready. There were discussions which were never ending. Apart from that, the interest that he has in this center was evident in his going into even small details in most of our meetings. Without him, I could not have been here for the last 2 years, and the institution would not be like this without his cooperation. George Lim, I met him in Singapore a year back when I went there. He was very courteous. He met me with all others from the Singapore International Mediation Center. I gave him a proposal that we want to work with him, and we needed their cooperation to make mediation more acceptable in this country. He readily agreed that he would be willing to assist us in making mediation more popular in this country, which would be an appropriate dispute resolution. And about 4 months back, when I spoke to him, I said that it would be better that we have a training session for about 2 days here. And people from the industry, general counsel from law firms, and some senior counsel would be benefited by the training that would be given by George Lim and his team. He readily accepted. We had a 2-day training session yesterday and the day before. I interacted with the participants and trainees. All of them are extremely happy that they have come here. And some of them told me that they would have missed so much if they were not here. Equally, Mr. George and his team are highly appreciative of the trainees for the interaction, for the interest that they took in the training session. Thank you, George Lim, and V. Meng, CEO, Gregory Vijayender, Senior Counsel, and Seng Ong, former Executive Director, Singapore Mediation Center. We acknowledge your presence here, and on behalf of the Hyderabad International Arbitration and Mediation Center, thank you very much. Why this center? Why did we have to start an arbitration center in Hyderabad? And why an arbitration center? See, the question which we were asking initially was taking into account that there is an imperative need to offload the burden in the courts, especially in India, and the need for a swift and efficient alternate dispute resolution mechanism. That was the idea with which we started the center. I should confess that initially our focus was on arbitration, but we thought that we should include mediation also along with arbitration, because we thought the future mediation might be a better alternate remedy than arbitration, which is as cumbersome as litigation. I think this is the only center in India where we have arbitration and mediation together. I'm told that there are about 34 centers in India, some of them doing very well, some of them trying to pick up, but most of them focus on arbitration. There might be mediation centers also where they focus on mediation. But we are a mixture of both and make a good progress. We have done about 33 matters, 10 arbitrations and 23 mediations. But the heartening thing is that we have done disputes worth $700 million. So this is something which we really tested. My friends from Singapore would vouch that even the Singapore International Arbitration Center took more than about 10 years, 15 years for them to start doing well. Thanks to the cooperation of everyone, especially the judges of the High Court who are present in good number here, more than what we expected. And the future looks very promising, especially on the mediation front. Persons who have undergone training and the others who are also interested in doing mediation. Let me tell you that mediation is not an old boys club. It can't be restricted to a few people. It can't be restricted to the legal profession also. There is a misnomer that arbitrations and mediations can be done only by people from the legal profession. Let me tell you, my friends, domain expertise is very important in both arbitrations as well as mediation, mainly mediation. Take Hyderabad. We have a growing construction industry here, and there are thousands and thousands of disputes. A person who is well versed in construction would be a better mediator than a lawyer. And I should confess, we were told when we were judges that judges do not make good mediators. Only to take up the challenge, I underwent 2 courses to find out why judges can't become good mediators. That's also a misnomer. I have a request from Justice Naveen Rao, along with his colleagues, who are planning for a mediation course for the High Court judges in the vacation. I welcome that. Judges have to be trained. Yesterday, George Lim was telling us that he went to Fiji to train judges there. This is how people would learn the importance of mediation. And after I underwent the course in mediation, as was asked by the participants yesterday, apart from what they have learned on the subject of mediation, the question that would be asked by these leaders would be as to whether they have become better individuals after the training, whether they have developed a different perspective of life, learning what empathy is, trying to find out what the problems of the persons is, dealing with them with patience, and not imposing a person on the others, but otherwise facilitating a settlement. All these things are to improve your own personality. So this is what they would have asked you yesterday. I'm sure all of you who have participated in this training would go back as better individuals apart from being qualified mediators. And George Lim has promised all of you, I think, that you will be empaneled in the Singapore International Mediation Center. Please spread the word. Singapore International Mediation Center is not a small body. They do cross-border mediations worth billions and billions of dollars. So even professionally also for lawyers, that would be a very good opportunity to interact and learn and also make a living for yourself. Thank you very much.
Thank you, Justice Nageswara Rao. Your remarks, opening remarks, have given a lot of hopes to all of us. Otherwise, we were definitely in a little despaired condition, but every time we hear you, we really regain that confidence that we can be good mediators as well, alongside legal professionals. Now, I invite Justice Hima Kohli to address the gathering here. Justice Kohli was born in Delhi, completed her LLB from University of Delhi, Campus Law Center in 1984. Before being appointed as a Supreme Court judge, she had held the position of Chief Justice of the Telangana High Court. She is very active in promoting mediation as an alternative dispute resolution forum, emphasizing the role of the judiciary in protecting the ecology of environment and highlighting the function of family courts in resolving disputes. In addition to carrying out her official duties as a judge, she participated in several national and international symposiums and conferences on ADR and environment protection and others. I read one of the quotes I always read, and whenever I do some women empowerment program, I read ma'am's quote. She said, "Women are going to be the dominating workforce in the next few decades. Equity ensures their place is in the sun." So when she took over as a Telangana Chief Justice, I have to be a little partial here towards my women clan, that there was a really brightness of sun shining in all women advocates' lives. Big round of applause to Justice Kohli. Please, ma'am.
Very good morning to all of you. Justice Ramana, former Chief Justice of India and the inspiration behind IAMC. Justice Ravindran and Justice Nageswara Rao, former judges of the Supreme Court of India and trustees of IAMC. My colleagues, judges of the Telangana High Court, Mr. George Lim, Senior Counsel and Chairperson of SIMC, Mr. Wee Ming Chuan, CEO SIMC, Mr. Seng Wan, former Director SIMC, Mr. Gregory Vijendra, Senior Advocate, distinguished guests, members from the legal fraternity, and friends from the media. I'm indeed delighted to be present in my favorite city on the occasion of the first annual Mediation Day organized by IAMC Hyderabad to speak on a subject close to my heart, role of mediation in India's judicial system and the potential for India to become an international hub for mediation. India, as you all know, has a rich tradition of alternative dispute resolution, and mediation has been an inalienable part of this tradition for centuries. However, only recently, mediation has gained the recognition that it deserves in the Indian legal system. In ancient, medieval, and even contemporary India, disputes were resolved through a process which we call the panchayat system, which was a form of community mediation. In addition to panchayats, there were other ADR forums also that were practiced, including arbitration. So the use of ADR in ancient and medieval India has been quite comprehensive. For example, during the 9th to the 13th centuries, the Cholas, a very powerful dynasty that ruled over southern India, had a very well-established mediation and arbitration system. The Chola kings used to appoint officers to resolve disputes with the traders and merchant guilds, and their decisions were considered final and binding on the parties. Use of ADR in ancient medieval India has highlighted the importance that India as a society places on resolving disputes peacefully and through consensus building. It is a tradition that has continued to this day and has strengthened by recognizing mediation as a viable means of dispute resolution in the Indian legal system. ADR, also described by many as appropriate dispute resolution, offers a basket of options to parties for resolving disputes outside of the traditional court system. And that is not to say that we can do away with the court system. The very fact that we use the word alternate goes to show that the court system will always be there. So ADR includes arbitration, negotiations, mediation, conciliation, and lok adalats. And they're all different facets of ADR. There are also the hybrid modes of ARB, Med-ARB, then Med-ARB, and so many other modes. There was a time when the public was so ignorant of the word mediation that I remember they would always confuse it with meditation, a word that is phonetically similar. But with more awareness, things have changed for the better. As we know, mediation is a voluntary process. in which parties attempt to resolve disagreements with the assistance of an impartial third party, who we call the mediator. Mediators do not impose a solution on the parties. Instead, they create an atmosphere where the disagreement between the parties can be resolved and dissolved amicably. The party's choice determines the mediation process. In other words, they call the shots when it comes to the process. The benefits of mediation are plenty. They include non-adversarial and the voluntary nature, flexibility and confidentiality of the process, the speed and cost-effectiveness, and finally, the consensual settlement that leads to further avenues of collaboration. As a mode of ADR, mediation helps to reduce the caseload of courts, and it contributes towards the financial and commercial growth of the country. At present, mediation in India can be categorized under three heads. The first one is the court-referred mediation, as courts can do so under the CPC, the Civil Procedure Code. Then the private mediations, for instance, under contracts that contain the mediation clause. And lastly, as provided under a specific statute, take, for example, the MSME Act, the Commercial Courts Act, the Consumers Protection Act, and so on and so forth. So mediation services are provided by courts or tribunals known as court annex mediation centers, and by private ADR or mediation centers, as just pointed out by Justice Nageswara Rao. As per the data published by the National Legal Services Authority for the year 21-22, India has 464 ADR centers, 570 mediation centers with 16,565 mediators all over the country. In this duration, nearly 53,000 cases have been settled through mediation as per that report. Various countries, including Australia, Singapore, and Italy, have stand-alone laws on mediation. This vacuum in the legislative regime is going to be filled up very soon in our country, with the Ministry of Law having drafted the Mediation Bill 2021 that seeks to promote mediation, particularly institutional mediation, and provides a mechanism for enforcing mediated settlement agreements. Presently, the bill stands referred to the Parliamentary Standing Committee on Personnel, Public Grievance Law and Justice for discussion. The bill is an acknowledgement of the significance of mediation in the Indian legal system. It also seeks to establish a comprehensive framework for the mediation process, and it encourages its use as a viable option for dispute resolution. Once legislated, courts would be required to refer parties to mediation before proceeding with the case, unless there are compelling reasons for not doing so. There are several features of the bill, just to touch upon a few: the fixed timeline that it offers, the proposal to establish an Indian Mediation Council that will register the mediators and recognize mediation service providers, the fact that the mediation agreements once signed will be binding on the parties as decrees enforceable in law. There will be limited scope of challenge to a mediated settlement, and the bill also contemplates the confidentiality clause relating to discussions, documents, and information exchanged in the course of mediation. The bill highlights the impartiality and independence of the mediator, who ought to be accredited and trained to conduct the process effectively. And that is where the trainings will help anybody who's in practice or who is outside of practice and proposes to be a domain expert to be a trained mediator. The bill contemplates a mandatory pre-litigation mediation in civil and commercial disputes. So some of the questions that have been raised about the insistence of participation in a process that is ordinarily considered voluntary in nature. Incidentally, the Niti Aayog 2021 report had observed that this model of compulsory mediation, up to a few sessions, has shown positive results in countries such as Italy, Brazil, and Turkey. In other countries, including in Australia and England, mediation for certain disputes is statutorily mandated, or the courts are empowered to order mediation. So the Mediation Bill 2021 provides a robust legal framework for mediation in India. It recognizes the importance of mediation in resolving disputes. It provides for a mandatory referral to mediation, ensures confidentiality, establishes defined roles of the mediators, and the cross-border disputes settled by the mediations through mediations will be recognized as awards enforceable in law. All this legal framework will go a long way in making mediation a more effective and a more efficient mode for resolving disputes in India. Talking of court-annexed mediations and private mediation centers, and I emphasize, it's not versus, it is and. As we have gathered here to discuss the importance of mediation in resolving disputes, I may emphasize that the need for the existence of both the court-annexed mediation centers and private mediation centers cannot be underestimated. They must work in tandem towards a common goal of spreading the mediation culture. Court-annexed mediation centers settle pending litigations that are pending in courts and are referred by courts. They have played a critical role in spreading awareness of the process and promoting mediation in India as an alternative to traditional litigation. Besides the financial burden of engaging a mediator and arranging the venue, the court-annexed mediation centers have made that more attractive and accessible to the public. They also give the confidence to the litigant that courts can and are monitoring the entire process from the beginning to the end till the settlement comes back to the court or the matter is returned unsettled. Private mediation centers function at a different level as they deal with pre-litigation media disputes and can offer several advantages over court-annexed mediation centers. They can provide a more tailor-made approach to mediation, offer specialized services and expertise to parties seeking resolution of their disputes. They can provide more flexible schedules, allowing parties to choose the venue and the time for conducting the mediation sessions that may be more convenient to them. More importantly, encouraging private mediation centers can help to democratize the access to justice by allowing for greater competition and diversity in the mediation services. By promoting private mediation centers, individuals and organizations are empowered and equipped to take control of their disputes and choose a mediator or a mediation center that is best suited to their needs. I may hasten to add here that encouraging private mediation centers should not be viewed as a criticism of the court-annexed mediation centers that have shown tremendous results over the almost past 2 decades. But both types of mediation centers operate in different areas, have their own strengths, and are essential components of the entire dispute resolution firmament. The aim should be to create a harmonious and a collaborative relationship where one can complement the other and each can adapt best practices from the other. Encouraging court-annexed mediation centers and promoting establishments of private mediation centers like IAMC and many others will create a robust and an inclusive mediation ecosystem that will foster effective and efficient dispute resolution. Now, just to touch upon the impact of COVID-19 pandemic on mediation, which has taken this on a different track entirely. The COVID-19 pandemic had unleashed an unprecedented global crisis affecting all aspects of life, including the legal system. In India, just like other countries, the pandemic forced the judicial system to adapt itself and evolve to meet the challenges thrown during the lockdown. This meant harnessing artificial intelligence to conduct courts virtually, laying down mechanisms for online filing, establishing e-kiosks for easy access to those living in remote and inaccessible places. In the ADR field, one of the most significant changes has been the shift towards online dispute resolution, which we call ODR mechanism, including online mediation. So online mediation has now emerged as a preferred mode of dispute resolution, primarily attributed to the restrictions imposed recently by the pandemic on physical interaction. The transition to online mediation presented several challenges that required careful consideration and attention. One of the most significant challenges was to identify a reliable and secure platform to support the mediation process. Just to share with you, at that point in time when the pandemic was on, I happened to be chairing the committee that runs the court-annexed mediation center established by the Delhi High Court known as Samadhan. And I remember how we decided to place urgent orders to purchase licenses for operating virtual communication platforms to start the process. And sometime in the month of May 2020, as you remember, the pandemic had broken in the end of March. So looking at the increased need and adaptability of all the stakeholders, 30 to 40 matters were being listed for online mediation on a daily basis at that time, with one slot of 1 hour for each matter per day. So that is what had started, and it was a trickle that became a deluge in Samadhan over a few months. Simultaneously, we prepared guidelines for conducting the online mediation that the mediators and the parties involved could communicate effectively, confidentially, and the data protection regulations could be complied with. The lessons learned were robust technical support was required, comprehensive infrastructure was necessary, and clear protocol for using technology in mediation was imperative. The process of signing and sealing settlement agreements for ODR was also important to make it foolproof. In all these processes, be it physical, be it online or hybrid, let us not forget, we must recognize the importance of the human element in mediation. The mediator, whose role is critical in facilitating effective communication between the parties involved, and the mediator who helps them find mutually beneficial solutions. In the case of online mediation, mediators need to adapt their skills to online environment, including building rapport and establishing trust with the parties involved, all without physical interaction. Currently, there is no specific regulations governing ODR in India, which are mandated by the statute, but ODR providers and users are relying on existing legal frameworks, best practices, and data protection regulations to ensure that their online mediation activities comply with the relevant laws and regulations of the country. As ODR mechanisms continue to gain traction in India, rules and guidelines are bound to come up and provide more clarity. With proper infrastructure, with proper protocols and human skills in place, it has the potential to democratize and improve the mediation experience for all stakeholders. Way forward, very briefly, the way forward for India to become a global hub for mediation is multi-pronged to my mind. It requires a concerted effort and collaboration of all stakeholders, including the government and non-government organizations, industries, PSUs, NGOs working in the field, the legal profession, the civil society organizations, and end of the day, the civil community, the end users. So my suggestions will include increased awareness. This can be achieved through workshops, through seminars, through symposiums, and outreach programs like this one organized by IAMC that target businesses, communities, and individuals. Develop a robust infrastructure. This includes a pool of trained, experienced mediators, mediation centers, and state-of-the-art facilities, a robust legal framework that supports the process. Next, encourage international participation. This can be done by partnering with international organizations like SIMC and incentivizing foreign parties to use the Indian mediation services. Fostering a culture of mediation, and this can be achieved by encouraging mediation in universities, in law colleges, in educational institutions, at workplaces and communities. It is essential to provide and to encourage mediation as a valuable tool for conflict resolution that can bring long-term benefits to all the parties concerned. Lastly, continuous improvement of the legal framework. Of course, the mediation bill is a positive step, and soon it will be hopefully legislated. in India, democratizing the whole process. But legal frameworks, once in place, will have to be constantly reviewed and revamped to remain responsive to the evolving needs of the society. To conclude, mediation is a vital tool for resolving disputes. It is a positive step towards access to justice. Through mediation, parties become partners to the solution rather than the problem. Just as it is important for the judiciary at every tier to support the mediation process, it is equally important for the legal community to create a robust ecosystem around mediation. This is especially applicable to those involved in drafting contracts, so that med-arb clauses are incorporated as a rule rather than an exception. Time is not too far when mediation will be cherished as a viable career opportunity for students and young practitioners. This is when the true potential of mediation as a preferred choice of dispute resolution will be realized. I would therefore urge universities and law colleges to include mediation in their curriculum and impart regular trainings, which will go a long way in improving the quality of the next generation of mediators. With continued efforts and cooperation from all stakeholders, I'm sure that India's potential as an international hub for mediation can be realized as long as it can offer more efficient, more cost-effective, and satisfactory methods of resolving disputes. So, mediation is not just a process. It is a state of mind which brings people together on a common platform and builds bridges of mutual understanding and collaboration. Thank you.
Thank you so much, Justice Kohli. As usual, that's a very empowering insights and encouragement for all of us here who is going to take mediation as one of their career aspirations. Now I warmly welcome just the former Supreme Court, the former CJ of India, Justice N.V. Ramana Garu, to address the August gathering. I have already read about his glorious and very radiant background of his judicial career. Though I want to repeat it because of the paucity of time, I just do not want to repeat it. I have actually come across one of the quotes that he said, "I come from an agriculture background. After obtaining BSc degree, my father's encouragement, I took up law. I was keen on joining active politics, but destiny decided otherwise." Sir, that your destiny has turned in the favor of our destiny, which resulted in having IAMC in Hyderabad. So Justice Ramana is the protagonist and the author of bringing IAMC to Hyderabad and pegging the Telangana on the world map as far as the mediation and ADR is concerned. So we are all very thankful to Justice Ramana for creating this kind of venue where all the mediators and ADR specialists come together, learn and share, and take the ADR and especially mediation movement forward. Now I welcome our former CJ of India, N.V. Ramana Garu, to please come and address this August gathering. Thank you, sir.
My dear sister Hima, Judge Supreme Court and one of the life trustees of this Hyderabad Center, Honorable Justice Ravindran, former judge and life trustee of the center, and Justice Nageswara Rao, former judge, life trustee of the center. My brother and sister judges of Telangana High Court, and Mr. George Lim, Mr. Wimeng Chuan, Mr. Sengan, and Mr. Gregory Vijaya, senior advocate, other senior advocates, and distinguished panelists who joined this event from various parts of the world, Sri Tariq Khan, Registrar of the Center, other distinguished guests, friends from media, ladies and gentlemen, namaskar. Priya Iyengar, a mediator, నాగేశ్వరరావు గారి గురించి చెప్పేటప్పుడు తెలుగులో ఒక చక్కటి పద్యాన్ని లాంటిది కవితను చెప్పింది. ఒక అంతర్జాతీయ సమావేశంలో తెలుగు విన్నందుకు నేను చాలా సంతోషపడుతున్నాను, తెలుగువాడిగా గర్విస్తున్నాను. థ్యాంక్ యూ వెరీ మచ్. ఐఎమ్ వెరీ మచ్ ఎమోషనల్ and at the same time honored to be here, to be a part of this first India Mediation Day being hosted by International Arbitration and Mediation Center, Hyderabad. And you all know that my association with this center, and I deeply appreciate the trustees, registrar and other members who is organizing and who are the persons planned for this program and inviting me to participate in this program. As I stand before you with more than 22.5 years of judicial experience as a judge, I have no hesitation to say that the ability of resolving the dispute in a faster pace that will help and the growth of a society, a country, or a nation, or a world. So once I want to say about how this origin or the starting point of this center. Without missing the exact things what happened, I want to narrate because I have written nowadays because of the I'm also becoming old, so I have to narrate exact conversation taken place between Justice Nageswara Rao and me. During one of the days just taking after the Chief Justice, Justice Nageswara Rao came to me for a cup of coffee. Just we are discussing several other issues apart from the progress of this arbitration center and legal aid centers in the country in the Supreme Court. Because Nageswara Rao is one of the, he is the chairperson of the Committee of Artificial Intelligence. When Justice Bobde thought to introduce artificial intelligence in Supreme Court, he was put in charge of that center. He has taken a lot of time to create a artificial intelligence center in Hyderabad in Supreme Court. When we are discussing about that, he came actually to say to me, please relieve me from the center. It's waste of time because nobody is cooperating in the government, and so there's no meaning of continuing wasting my time. So in that context, I said that, okay, then we discussed about the arbitration. Initially, I thought of actually, when this topic came, starting a small level arbitration center in Hyderabad. But Nageswara Rao made it to international level. And he's a man of big thinking. So that's how the proposal of Nageswara Rao was accepted, and we thought of working on that. And in fact, I had my own doubts whether we can make it a big way. But now, after seeing this growth and development, I'm very happy and congratulating particularly Nageswara Rao and Honorable Justice Ravindran, who is a busy arbitrator and most respected arbitrator in the world, spending a lot of time coming all the way from Bangalore and attending the programs and making the rules and all that. I don't want to say much about my sister, God-given sister, Hima, because I know how much strain and stress she suffered and how much scoldings from all of us That day she is in literally tears when signing the trust, this deed in her house. Hima, I'm very happy, and now I think you also realize the whatever hard work and stress and strain is fruitful and now coming this shape. I thank all of the life trustees who are working hard, and including Mr. Tariq, who is a registrar. Initial days, you know, it's difficult to face a lot of problems, but you are doing your best. I'm very happy for that. I want to start Joseph Greenbaum, who is one of the renowned international mediator, saying that an ounce of mediation is worth of a pound of arbitration and a ton of litigation. So the value of the mediation is becoming more important, and everybody is recognizing in the world. And it is one of the most powerful tools to resolve the disputes and take forward to the growth. Fortunately, the world across now realized the importance of the mediation and arbitration and other alternative methods of disputes in resolving the caseload in the traditional court system. The tilt towards the arbitration is one of the welcoming feature, and it is now to expand the attention to mediation and other hybrid systems. The litigants opt mediation as the first step in conflict resolution. Many of the cases languishing in the courts would have been resolved much earlier. And all these days, the power of mediation is understated. It has deep roots in our culture and the society. And I often quote from the epic Mahabharata as an example how the early attempts of Lord Krishna in mediating, resolving the dispute between Pandavas, Kauravas was failed. And ultimately, it is this failure caused a disastrous consequences, and Mahabharata war has taken place. So, the traditional times onwards, this concept of mediation is there in our culture and history. In the increasing complex relationships and conflicts today, there is a need to develop more systematic modern forums, rules, and techniques. India, after 1991 liberalization of the country, now we are operating in a global market. And there are a lot of increasing cross-border commercial transactions. With every new relationship comes a potential conflict, and we must accept the need for legal remedies that cater to all these conflicts and disputes. Enforceability is the major concern of a mediation. We have to focus on that. Different methods of being devised to tackle this issue. For instance, mediation, arbitration, mediation and arbitration, and similar hybrid modes which we have to see. In 2019, the Singapore Convention on Mediation Understanding or Resolution Settlement Agreement, where India is one of the signatory, has made a momentum in the mediation and arbitration in this country also. On 7th August 2019, India signed as a party to the agreement, and to promote global efforts to create a mediation environment to resolve the cross-border commercial disputes. Now, the government is contemplating to introduce the mediation bill of 2021. The bill has definitely moved the spotlight onto the potential and scope of mediation. The bill aims to encourage the use of the mediation as a faster, more cost-effective means of resolving disputes. Now, I was told that the matter was under scrutiny by the Parliamentary Standing Committee, and the Parliamentary Standing Committee has examined the bill and made several valid recommendations. I hope the Parliament in next session will make it a law, so it is easy to, in a systematic way, to establish mediation movement in this country. Some of the suggestions made by the parliamentary committee is very worthwhile about particularly about the limit of the dispute should not be there, because they introduced in the bill less than 3 lakhs of rupees, there is no mediation, and there is no time limit, etc., etc. Now they are all, I think they are going to take care of those issues. I told earlier that the primary challenge is the credibility is the most important for mediation, because the process of mediation must be, we have to create the confidence and the credibility. We must take the steps of the process of mediation must be speedy, and the end result must be fruitful and it reach through the party without any further delay. We now need to focus on domain expertise, and positive experiences in the mediation will gain attention for being worthwhile and delivering lasting solutions. Now, the crucial role of a mediator is often understated. Mediators need to develop emotional intelligence, being pursued by practical consideration, have the ability to communicate effectively, strategize at every stage, conduct oneself even handily, be spontaneous, possess the ability to build trust, assess the undercurrents of the strained relationship and foster cooperation. These are the qualities which a mediator has to be. These are the far easier said than done and require conditioning and training. The complexity of issues is increasing, and the skills expected in the mediators are getting more nuanced. Perhaps the biggest challenge that we face today in creating a shift in the mindset of the public, the strong impression of the people that whenever there is a dispute, they have to resort to traditional litigation, pay a huge amount of fees, and wait for years together for resolutions need to be changed. In a world where time is valuable, speedy settlement of disputes is need of the hour. Mediation is the only solution to this. The apprehension of the people that the settlement arrived through mediation is not valid needs to be addressed. Bringing in this shift in perception is possible only when the government, judiciary, and more particularly advocate come together. Legal practitioners must make an effort to educate parties on alternative methods of resolution and suggest mediation as an effective tool to resolve disputes. This campaign has to be taken forward on a large scale. The mediation or settlement system which existed earlier, particularly in the trade and business community, has to be restored and encouraged. Quality training program in judicial academies and bar associations has to be conducted to give proper training and teach the skills and techniques of mediation. I am certain that the training conducted by the Singapore International Mediation Center experts and the discussions today will bring in a lot of skill-based learning and perspective for all the members participating. Opportunities like this equip the participant to assess, critique, and build the path to move forward. I am happy to note that the participants in the event today are going to draw benefit from the rich experience and vast knowledge from esteemed panelists. We are privileged to have Mr. George Lim, Honorable Chairperson of SIMC with us today. His legendary act of concluding a dispute worth $1 billion in just 4 days is part of mediation folklore. A pioneer in the world of mediation, Mr. Lim is synonymous with cross-border dispute resolution. Thank you, Mr. Lim, for coming all the way from here. There may not be any renowned mediation center which has not benefited from his guidance in formative stage. We also have with us Mr. V. Meng Chong, CEO of SIMC. His experience of running the prestigious Singapore International Mediation Center and conducting mediation training will help us learn a lot. I welcome all the esteemed panelists and guests to this beautiful city of Hyderabad and thank them for agreeing to join us in this event. The field of mediation would definitely benefit from such regular and dynamic training and sharing of knowledge. It leads to evolving new techniques and producing more research which forges new developments. During the inception of this institution, I was particular that its supporters and promoters mediation and not just arbitration, and later on now we have taking a lot of giving importance to mediation also. I'm happy that the name of the institution apportions the importance equally to arbitration and mediation. From the bench, I always advised litigants to opt to mediation. And this center in Hyderabad with state-of-art facilities has set high benchmark for infrastructure development. As some of you might be aware, it is all begin with the thought of setting up a small facility of arbitration, which I narrated earlier. I'm happy and I extend my sincere thanks to the Honorable Chief Minister, Mr. K. Chandrasekhar Rao, who contacted his own after knowing that we are thinking on this and helping us a lot. At the same time, I am also thankful the bureaucracy and the Minister, Mr. K.T. Rama Rao also, wherever he goes, he introduces this center across the world. And it is because of the proactive approach of the government, the center becoming a reality within a period of 6 months' time, which is a record itself. And the way the government is extending their help, allotting land and money to make a permanent building, it's a good sign, and I'm once again thanking this thing. I must also say thanks to Chief Justice Singapore, Mr. Justice Sundaresh Menon, who promised that he will extend all his support to encourage and support this mediation center. It is the encouragement of all of you, particularly my brother and sister judges of the Telangana High Court and NCLT members, who is trying to send some matters of mediation and arbitrations to this center. I'm very happy, and I request them to encourage and support this mediation center. You are all aware that after starting this mediation center within this short span, the Honorable Prime Minister also inspired, and he has taken a clue and immediately started another world-class mediation center in Gujarat. The Government of India also giving some funds. So it's a good country, across the country, people wants the mediation is a method of resolving disputes. And so I congratulate all of you giving the opportunity, and I strongly urge all the participants to give wide publicity or propaganda to this center and encourage. I request my media friends also to broadcast and give wide publicity to the programs of this center. So the common man also knows that there is a center. They can come without spending much money, can resolve their disputes. Before closing my talk, I want to quote Professor Hiskisya Asifa. I quote, "Mediation and reconciliation work is about a profound quest for justice and social transformation. but at the same time, they are about service, solidarity, about exploring and rediscovering the human spirit that has been lost or shattered through human conflict, cruelty, ignorance, and greed. Thank you once again, all of you, for giving me this opportunity. And before closing, I want to share my memory. Long back in 1996, I have undergone 1 week training on mediation and arbitration.
Thank you so much, Honorable former Chief Justice N.V. Ramana Garu. That was truly inspiring, and the pearls of wisdoms are really need of the hour for all of us. That's nothing but walking the talk, sir. Now I request Honorable Justice Shri Ravindran, R.V. Ravindran Garu to give the closing remarks. Justice R.V. Ravindran enrolled as an advocate in March 1968.
Leave it for want of time, you can.
Okay. So, but I want to add one point here, sir. 1997, I had a precious opportunity of representing myself in his court in Karnataka High Court. I had so many orders that has come from that bench. And after so many years, I am seeing him back here. It's really cherishing my memory. Thank you so much, sir. In one of the bar and bench interview, Justice Ravindran has said, sir, to be successful, mediation requires awareness about advantages among disputants, increased availability of professional, neutral mediators, and the support and trust of the bar by accepting mediation as an effective alternative dispute resolution process. These words really means a lot for this occasion and for what Honorable Justice is extending for IAMC. That's again, it's walking the talk. I welcome you, sir.
Thank you. Justice Ramana, former CJI, the creator and author of IAMC Hyderabad, my beloved co-trustees, Justice Nageswara Rao, who gave the idea for setting up the center, and Justice Kohli, who as Chief Justice extended formidable assistance and is doing wonderful work even now. I only wonder why Justice Ramana, he had absolutely good reasons for selecting Justice Nageswara Rao and Justice Kohli as trustees. As I said, Nageswara Rao gave the idea and Justice Kohli implemented. Where did I come from? I do not know. Ramana must have thought, Unni Pedaina, Konchmu Telugu Telchuno, Konchmu mediation Telchuno, Unni Koda Unni anta. Thank you, Mr. Ramana, for adding me, though I am not from Telangana or Hyderabad. And anyhow, we will all try to, we the trustees will try to live up to your expectations in making this center a world-class center. And lastly, Mr. George Lim, the special guest today. When I say Mr. Lim, you can take it, it is deemed to have included Mr. V. Ming Chon and Mr. Vijayendran and Mr. Wong. The four worked as a wonderful team. I remember the days of, Dhoni and Jadeja rotating the strike. The manner in which the, not rotating the strike, but they shared and seamlessly fitted into one another to train in the last 2 days. It was a wonderful thing to, I had the privilege of watching them. And let me tell you that it was a great performance, and we hope that you train other mediators also in Hyderabad and other places. please remember you are creating a lot of competition for yourself. Thank you. Anyhow, thank you. Thank all of you for being a wonderful training team. The honorable judges of Telangana High Court and the persons who underwent training, they were elite. I mean, it was a great disadvantage for me. You see, there should always be, a mixture of good, bad, and ugly. But you had, as the trainees, the best, the elitist. I do hope they all become good and sound mediators and reduce the disputes in India. And very a number of members of the bar and friends. It is, and I forgot, a lot of very eminent and distinguished panelists are there who are themselves renowned mediators and mediation trainers. We welcome them also. We are celebrating the India Mediation Day. That is because in the center, we firmly believe that the mediation culture should be developed. Mediation cannot survive unless we have a culture of mediation. What is this culture? The culture of mediation is this. Number one, knowing about mediation. Knowing about mediation is not just thinking that you have a third party, neutral third party to help you. Knowing about mediation is knowing about the advantages of mediation. Knowing about the advantages of mediation is knowing about the disadvantages of, adjudicatory process of dispute resolution. For example, delay. For example, uncertainty in outcome. You go to a court, you go to an arbitrator, you spend lakhs of rupees, crores of rupees, time, you do not know you are going to win or lose. The uncertainty. Then the inflexibility. You have no choice in the decision. The choice, because in mediation is I had the experience of sitting with these people and learning how they created opportunities in a settlement which they would not have thought of when they had the dispute. Instead of resolving the dispute, they went steps ahead and created for themselves rights which were non-existent. This kind of choices, this kind of making improvisations, this kind of continuing the relationship is possible in a solution in a mediation, which is never possible in a decision of a court or an arbitrator. Next is, of course, high cost. We need not talk about the years and decades of pendency, not only in courts, but before in arbitrations and then in courts. When you think of, mediations, which can be settled in days or even $1 billion matter in 4 days, imagine the cost that is saved. And the difficulties of execution. What happens in a court is, when a decree is given, when an order is made, award is made, the party against whom it is made is agitated. He hates it. Therefore, he tries to do everything to avoid the implementation of the judgment or the award. But in a mediation, that does not happen because he is a willing party to the solution. He is ready to implement it. Therefore, except in very negligible cases, when there is a mediation settlement, there will be no consequential litigation or need for implementation. The last is, of course, the hostile atmosphere in courts, and that is also avoided. Therefore, these are the advantages. If all these advantages of mediation is known, mediation is something that you look forward rather than not like, say, going to a dentist for a tooth extraction. It's not like that. Therefore, court litigation is, but here you go with a positive attitude. That itself is something that is very good. Second is, it is not sufficient if you know about mediation, that you should remember about mediation when a dispute arises. Unfortunately, many people, in life what happens, whenever I go in this YouTube, if I see something about knee pain, I immediately note it. I have knee pain. Because virtually I have pain in every part, and YouTube has got solutions for everything. And I have got one full book of various remedies that are given. But what happens is, when really the knee starts paining, I would have kept that book somewhere. So, knowing about the remedy, knowing that mediation is available is not sufficient. When you have a dispute, when your company has a dispute, when your friend has a dispute, when you yourself have a dispute, think that mediation is the remedy. I will not go to court, I will go to mediation. Now that is the second step that is necessary in a mediation culture. The third step in a mediation culture is, the first thing about mediation is, as against litigation, in litigation you only think of your strengths and always try to avoid mentioning your weaknesses. In a mediation, you are aware not only of your strengths, you are aware of the grievances, problems of the other side. In an open discussion, you come to know they also have something. They also have a grievance. They also should get some relief. If you develop that mentality, which goes to the fourth stage of having a mindset to settle, and settlement is not having 100% success, not getting Aishwarya Rai as the dream girl as the wife. You are going to end up with somebody, whether it is wife or husband. The absolute expectations are something else. What you are going to get is something else. And that mentality, if you develop in mediation, that you are going to succeed, but you are also not going to succeed in some matters, mediation is going to be very, very effective and successful. Therefore, we have to develop the mediation culture of knowing about mediation, thinking about it when a dispute arises, and using it and implementing it to decide our disputes. Now, I have a takeaway from yesterday. I was an observer. Mr. Lim was mentioning various things about mediation, advantages, and all that. I was impressed by one thing he mentioned in the end. He said, mediation teaches you to listen and then understand and then analyze and then discuss and then facilitate. What a wonderful thing. I did not understand what he was saying until he gave an example. He said, in his family, with his wife, with his children, his wife goes on talking, saying something. He says, yes, but he never listens. And even if he listens, he does not bother to understand, because his wife will be saying this, his son will be saying that. So if you do not listen, if you do not understand, the problem remains. It does not get dissolved. That's why, instead of problem dissolving, many marriages get dissolved. But if the takeaway from him is, because he is now a successful mediator, he listens to his wife, secret. He understands his wife, and he analyzes what she says and facilitates by accepting whatever she says. He is successful as a mediator. He is successful in life. I want all of you to be successful, not all of you to become mediators and be successful. Thank you.
Thank you, Honorable Justice Ravindran. That was really fun-filled, and we definitely required at the end of the session. Now we have come to the conclusion of this inaugural session. So, end is something, beginning in disguise. So we have a whole day laid out for us with eminent panels and so many things to learn. I want to close this session with a very beautiful quote by Mr. George Lim. He said, "Learn to mediate with heart, Once the parties feel that you're sincerely trying your best to help them, you will get there. That's the cherry on the top for this session, because mediating with heart is so important. Now that Justice Ravindran has brought in the family issue, we have no choice but we have to mediate with heart. And thanks for this wonderful session, and thanks for your patience. And I thank all of the dignitaries sitting here. And it's an honorable opportunity for me to even pronounce those names here from my side and narrate about their successes. And any mistakes that have been rolled out of my mouth, or there is a linguistic slur, it's just a mistake, and I sincerely apologize from everybody. Thank you. Thanks for this wonderful session.